If you've just been arrested for domestic violence and you are looking at your future and wondering, is this going to follow me forever? This video is for you because the truth is, with domestic violence cases, avoiding jail usually is not the hard part. Avoiding a criminal record that destroys your career, your reputation, and your future, that is the real fight. I'm going to walk you through exactly how to do that step by step. And don't click away after part one, because even if your case gets dismissed, even if you avoid a conviction, there's still an arrest record sitting there. And in part two of this video, I'll show you exactly how to wipe that clean too. Now, every case is different and there are no guarantees, but for clients who hired me last year and whose cases were resolved last year, over 95% of them avoided a conviction, completely avoided a criminal record. My name is Veronica. I'm a domestic violence criminal defense attorney, and I help people throughout the state of California put their cases behind them so that they can enjoy their lives and their freedom. Okay, so let's jump right in. How to keep your record clean after a domestic violence arrest. Let's start with the most important piece: how to avoid a conviction. For most of my clients, professionals in their 20s, 30s, and 40s, the fear, again, it's not prison, it's a permanent stain on their record. Now, yes, if you Google felony domestic violence in California, you will see up to 4 years in state prison. But honestly, unless there are serious injuries or you have prior arrests for domestic violence, even a mediocre general criminal defense lawyer should probably be able to keep you out of prison or jail. But here's the catch: even if you just get probation, that means that you were convicted. And in California, once you are convicted in a domestic violence case, that record is permanent. You can try to expunge it later, but there's no true expungement in California, and it will not be deleted from your record. It still shows up, it still follows you, and it can destroy future job opportunities, housing, professional licenses, you name it. So, what can you do to avoid a conviction? Let's talk strategy. Step one: stop charges before they're filed. After you're arrested, there's a window before your first court date where the district attorney is reviewing the police report and deciding whether to file charges in court against you. Now, if no charges are filed in court against you, then you cannot have a conviction. And here's the key part that most people miss: they don't have to file every single case. But if all they see is the police report, you are going to look guilty. That police report does not include your side. It's not going to say, he's a good guy, this was a misunderstanding, but we arrested him anyway. It's going to say, we arrested him, and here's why. So, if you have a lawyer who intervenes early, they can submit your side of the story. They can talk to the DA, present evidence in your favor, explain the context, explain how and why you are a good guy. And in some cases, that is enough to get the case rejected before it ever sees a courtroom. That is the cleanest win possible: no charges filed, no conviction. But there's still an arrest record, and I'll show you how to get rid of it in part two. Step two: let's say that charges are filed anyway. Here's how to keep your record clean. Sometimes you hire a lawyer too late, or the DA files charges anyway because the police report looks worse than you imagined. Now you have a case filed in court, but you still do not have a conviction yet. Here is how we fight to keep it that way. Let's go through a few ways that even when charges are filed, you can avoid a conviction. The first way is pretrial diversion or informal dismissal. Your attorney can negotiate with the DA to get the case dismissed in exchange for you doing things like classes, anger management, community service, or therapy. Sometimes we pursue mental health diversion, which involves filing a motion in court and asking the judge to give you therapy or mental health treatment in exchange for a dismissal. This isn't a one-size-fits-all solution. Your attorney needs to look at the case, look at you, and come up with the best strategy to get your case dismissed and avoid a conviction. And throughout this process, your lawyer should be building leverage by highlighting weaknesses in the DA's case, coaching you on what proactive steps to take to look good, like classes or therapy, and negotiating relentlessly to avoid that conviction. Now, the second way to gain some leverage and make it more likely to avoid a conviction is a motion to suppress evidence. In domestic violence cases, how this often comes up is, did you make statements to the police before being read your rights? If so, depending on the circumstances, we may be able to file a motion to suppress. Now, if we win, that means that your statements are thrown out. There's still probably other evidence against you. So that doesn't mean that the case automatically disappears. But every time your attorney files a motion, the DA has to either give up on that issue or file their own opposition, which is a written document saying all the reasons why whatever your attorney is requesting should not be granted. And this applies pressure, and that pressure makes better deals possible. The third way that your attorney can gain some leverage in your case to avoid a conviction is by body-worn video analysis. One of the most powerful tools that I use is getting transcripts of the police body-worn video. For most arrests in the state of California, most domestic violence investigations, if you were not arrested, there is going to be body-worn video, often hours of this because it overlaps if there are multiple police officers. And why do we get transcripts? Because that way I can show the DA exactly where the police report is misleading or flat out wrong. And guess what? Most DAs never even watch the video unless it goes to trial. This is hours of work. They have many cases and they don't want to watch the video unless they absolutely have to. They rely on the police reports. So I get transcripts, mark the timestamps, and say, let me show you something. Here's what the report says, but here's what really happened. I have my laptop there. I have a copy of the transcript. And when I combine that effort that most attorneys don't do, pointing out problems with their case, when I combine that with a strong character profile for my client, classes completed, therapy sessions, glowing background, it becomes very hard for them to justify pushing for a conviction. The fourth way to negotiate and avoid a conviction is through a DA supervisor meeting. So sometimes the assigned DA on your case will not budge. That is when your attorney needs to escalate. So most counties in the state of California, you then request a meeting with the DA supervisor. Usually it's going to be 30 minutes via Zoom or in person. And that's where we plead your case directly to someone who has more power to give you a better deal than the DA who is assigned to your case. In my experience for domestic violence cases, we almost always walk away from that with an offer that does not include a conviction. Now, with any of these options, the message that we send to the prosecution needs to be crystal clear. I'm not going to let my client walk away with a criminal record. A lot of defense attorneys will almost pretend to fight. They're just going through the motions, but they don't mean it and they're going to fold. We have to show them that that is absolutely not us. If they want to get a conviction, they're going to have to fight us to the end using a huge amount of resources. And for someone like maybe you, who hasn't been in trouble before, they start thinking to themselves, is it really worth spending the time prosecuting this person? Now let's talk about our final option to avoid a conviction, trial. Let's say that none of these negotiation strategies to gain leverage and avoid a conviction work. It's rare, but sometimes that happens, especially if you do have prior domestic violence arrests, even without a conviction, or if there are bad injuries that you are being blamed for. At that point, you are out of options to avoid a conviction except for one, trial. If you go to trial and win, you don't have a criminal record. But if you lose, now you have a conviction. Probation is likely, but jail or prison time also becomes possible. And the judge, not the DA, has control over your punishment. That's why trial is risky. But sometimes it's the right choice. It is really the only choice for you. I mean, for me, like many of my clients, if I were falsely accused and I was facing permanent damage to my law license, I wouldn't just take a deal that included a conviction to play it safe. I would go to trial because I know what's at stake, and I wouldn't take a deal that was going to give me a conviction and, ruin my life or seriously derail it, especially if I didn't do anything wrong in the first place. Part 2, sealing your arrest record. Okay, so let's say that you win either through negotiations or through trial. No conviction, case dismissed, charges dropped. You're good, right? Not quite. You still have an arrest record, and that can still show up in background checks, especially higher level ones for jobs, government contracts, professional licenses, etc. So here is step 2, how to seal your arrest record. Under California law, if you are not convicted, your arrest record will automatically be sealed after 1 year. But what if waiting a full year is just too long for you? You can hire an attorney to petition to seal it early. And if that is granted, then it's gone, it's sealed, it's clean, background checks will not pick it up. This is the part that most people overlook. And if you're applying for a job within that 1 year period, if you are applying for a professional license, guard card, anything like that, then this can come as a surprise to you. So it's very important that even when you succeed with step 1, you either know that you're going to wait a year and you request a copy of your background check at that point to make sure that the arrest is actually off your record, or you petition to seal it early if you cannot or do not want to wait a year. And in terms of ordering your background check, the easiest way to do this is to order a copy of your FBI Identity History Summary. It costs about $20. You can do it online. There are clear instructions on the FBI website. You don't need a lawyer or some expensive third-party service. The system, as you may have seen by now, is not perfect. And I have seen multiple FBI identity history checks that include an arrest or include a case still being open when it's not. Now, if there are inaccuracies, that's when you may want to hire an attorney to clear it up for you, get it cleaned up, and make sure that your background check does not cause you any problems in the future. Okay, so let's recap. Try to get the case rejected before court. If it is filed, negotiate for a dismissal or diversion, avoid a conviction. Once dismissed, make sure to seal your arrest record or at least double check your FBI identity history after a year to confirm that it's actually clean. That is how you go from scared and arrested to free and clear. If you are in California and you are facing this situation, book a free consultation with my firm. You can find the Calendly link down below. You can also find our number there. And look, this is what we do. We defend those accused of domestic violence. We know exactly what it takes to keep your record and your future clean. I hope you found this video helpful. If you did find it helpful, please don't forget to like, subscribe, ring the bell, and if you have a question or a comment, leave it in the comments.